All right. Good afternoon, everyone. All right. Let me begin by thanking everyone for turning up for this momentous occasion. I'll thank the members present here physically, those online, the Secretariat staff present, members of the press and the public. My name is Asimwe Anthony, the Vice President of Uganda Law Society, the Radical Nuba. Here together with the President. Everyone knows who he is. I'll still introduce him, Isaac Chimaze Semakade. We have our Treasurer, Mr. Arthur Isiko, the CEO, Christina Wori, together with us. We have Shira Tujasingra, who's also a staff member here, Manager LAP, and Christine, the HR, plus Enoch Chizito. We also have other council members online. The council member Northern, Mr. Garu, should be online. We have council member Western, Samuel Mumza, who is also online, and our acting secretary, who is also council member Eastern, Mr. Edin Anguru, online. Thank you for joining us. I greet everyone here in the name of council, secretariat, and the membership. Let me begin by apologizing for starting late. We had council business which overlapped and entered into our time. That's why we didn't start on time. So we really do apologize, especially to those who have been online since 2:30. That notwithstanding, we are here and we are ready to receive the presidential address. I hope everyone here is ready in the room. And people online, we are ready to receive the presidential address. Back on track? Bang the table? Back on track. All right, thank you. Over to you, Mr. President.
Good afternoon, colleagues. We are gathered here today following a public dispute. And this morning we had visitors, all the candidates in the Uganda Law Society election for a nominee or two nominees to represent the National Bar Association at the Judicial Service Commission, speaking in one voice about this dispute. And I must address the membership, the public, and the entire world about this dispute, in addition to any other communications that may have come from our council in writing. There has been a desire that we vocalize our views officially in a setting like this. I thank my colleagues from council who have discharged themselves from very important business to join us physically and online. And I'm also grateful for the many colleagues who are online intent to hear from their president on this issue. The time for timidity, colleagues, is over. It is time for radical action for judicial reform. It must be stated from the outset that the dispute that convenes us today is not about Justice Sekana Musa. Rather, it's about the system, both in its design and in its management, that makes the likes of Sekana possible. We talk about him only because he's a good example of how bad things have become in the judiciary. And of course, a bad example of himself. Like others involved in the operation of the legal system, he chooses to live with the crisis in the judiciary. Thus making it worse. A system of any kind requires regular maintenance as part of its management. As lawyers, we are not merely participants in the legal profession or the justice system. We are also part of its management and responsible, therefore, for its maintenance. A key part of maintenance of the judicial system in this country is the role assigned to the National Bar Association to take part in the oversight of the operations of the judiciary. This is the core meaning of the Uganda Law Society representation on the Judicial Service Commission. It is not a ceremonial role, nor is it meant as a reward for those in the good books of the judiciary or whatever leadership of the Uganda Law Society there may be at any given time. Our job there is to ensure that the judiciary, in the way it recruits, promotes, disciplines, and investigates members of the bench, delivers the highest possible quality of those who will have the sacred burden of adjudicating matters before court, whose outcomes will have real impacts on the lives of ordinary citizens. It was for this reason that we, as the Radical New Bar, insisted upon an open and transparent and competitive process through which Uganda Law Society representation to the Judicial Service Commission in terms of Article 146, Sub-Article 2C of the 1995 Constitution will be chosen going forward, making a clean break with the cozy and secret shenanigans of the past. 30 years of darkness can do real harm to any system that prides in transparency and accountability. And it is for this reason that all those comfortable with the arrangements of the past, the arrangements of darkness, be they amongst us here at the bar, or inside the judiciary itself, or in the executive branch, have sought to block us at every turn, to block our drive for transparency and democracy in the handling of matters affecting the legal profession. November, as some of you said, was Novembering, and December has also been Decembering. Why? Because we have brought light to the darkest corners of the legal profession of the judiciary, of the Judicial Service Commission, of the governance of this country, where it matters most. And if these shenanigans do not stop, January will also be Januarying. This is why we find ourselves having to single out Justice Sekana as the author of the current impasse. The current injunction against the Uganda Law Society Extraordinary General Meeting. We've singled him out for exposure and for repercussions. His blatant disregard for the law, bias, and abuse of power are not isolated incidents. Every lawyer who has practiced in the civil division in the last 6 years knows fully well that these are symptoms of a systematic rot, a malignant cancer that threatens to consume our entire profession. We have seen better days, and definitely we've seen better judges. This is the worst example of them all. And like bad patients, he and his kind seek to avoid taking the very medicine that will cure the illness affecting all of us. The recent actions of Judge Sekana have made it clear that urgent action is needed. That is why we have taken and proposed to take the following steps. We have issued Executive Order RNB number 3 of 2024, which withdraws the award of excellence from the bench previously granted to Judge Sekana in September 2021 during the leadership of past President Fiona Wall, urging all ULS members to boycott this judge for a period of 1 month. And more generally, calling for the boycott of all corrupt judges moving forward. Encouraging advocates and court users to protest unjust rulings and to demand radical reforms to our judicial system in accordance with the clear terms of our Executive Order RNB number 2 of 2024, which has received enormous support across the bar, and of course with some resistance in some pockets of the judiciary. We have launched an online complaint form for whistleblowers to report any instances of judicial misconduct. This platform will provide a safe and confidential space for individuals to share their concerns and help us build a stronger, more accountable judiciary. The first phase of this form is specific to Judge Sekana. Lawyers, judicial corruption, judicial incompetence affects you adversely more than any other member of the public. You are witnesses and you are victims. You are the most educated, sophisticated, and you can articulate it for the rest of the world to know. As the Radical New Bar Council, we have offered you the platform and the means and the moment. Please step up. Share the evidence with the world. This is a rotten judge. Stop whispering it. Make it public this December. We have directed the Judicial Service Commission to expedite investigations into all complaints against Judge Sekana since 2018 and publish findings by the 15th of January next year. There will be gross consequence for the Commission and the judiciary if we do not have any report about complaints against Judge Sekana. Justice Kabito, do not try me. Do not try me. Do not try me. I am not Fiona Wall. I am not Bunny Boy. Do not try me. If you do not give us a report of complaints against Judge Sekana by the 15th of January next year, there will be gross personal consequence for you individually. We have a report on you, and it's not good. No one investigates the Judicial Service Commission except the bar. Except the bar. We judge the judges, and we judge the commission that judges the judges. That is our power. Judge Kabito, do not try me. Do not try the radical new bar council. We have singled out Sekana to limit damage to the rest of the judiciary. Principal Judge Zeija, isolate yourself from Judge Sekana. Let him fall alone. Do not try us. You asked my vice president, what is it you think we can do? You asked derisively. You derided us. Test our power. On the internet, they say, FAFO. You can ask your children to explain it for you. We shall have another EGM before the 31st of January 2025 to assess the effectiveness of these preliminary measures and to discuss the judiciary performance report for 2024. We urge lawyers to study this report extensively and communicate to us their views, their comments, so that when we launch our response to the judiciary performance report of 2024, before the judges go into the annual judges conference, the country knows the true state of the judiciary, not those funny PDFs they circulated to a few invited media and giving them no time for questions. We are breaking with the shenanigans of the past. You issue a judicial performance report, the bar will study it for 90 days and issue its report. In response, we stand at a critical juncture in our profession's history, and I submit in the history of our experiment with constitutional democracy as a post-colonial state. The rampant misconduct of judges like Musa Sekana and their fellow travelers among us here at the bar has brought our judiciary to its knees. We know we have allies. We know we have champions of rule of law, of judicial integrity within the judiciary, and we sympathize with them. But this is not a time for giving accolades. This is a time for withdrawing them. This is a time for examining them, qualification for them. And this is a time for radical surgery of the judiciary, so that everybody in the judiciary doesn't have to worry about the harm that can come from one of their members and affect them vicariously. As lawyers, we have a sacred duty to defend the rule of law and to ensure that justice is served. On the 28th of September, you gallantly executed that duty by electing the Radical New Bar Council, which I lead, assisted by my most capable Vice President, Mr. Anthony Asimwe, my most capable Treasurer, Mr. Arthur Isiko, my most capable Interim Secretary, Mr. Eddie Nangulu, and my very, 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 very capable regional presidents, Mr. Egaru Emmanuel from Northern Uganda, Mr. Samuel Muhumuza from Western Uganda, and I think that's all we have. Right, yes. We are grateful to the Lord that we lost the dead wood in council. We are only saddened that today we haven't had a chance to offer membership its democratic right to express itself upon the conduct of 2 of our wayward members in council. But that decision has only been delayed. The members will have a chance to have their say once the judiciary has put its house in order and began to understand the true place of the bar in national affairs. You gave us a categorical mandate, a threefold mandate. Number 1, to fight for the independence of the legal profession. Number 2, to clean up the judiciary. And number 3, to tackle other systemic obstacles that have traditionally affected advocates' revenue, resilience, and representation. Basically, you asked us to bring a new vibe at ULS House. A vibe of doctrinal fidelity and fearlessness. In 80 days, we can say we have tried, but this is just the beginning. It is time for us to reclaim our profession from those who have unapologetically declared themselves enemies to our profession. We have gotten the chance to show you what they look like. We've given you the chance to weigh them, to measure them. And we are confident that with your support, they will be crushed. We have to take back our judiciary from the cliques and cabals of which Sekana is a cog. We have to fight for a justice system that truly serves the people. Now, colleagues, this is the radical new bar. We must be prepared to take bold action in the new year, in the new law year, including, I repeat, boycotting corrupt judges, protesting unjust rulings, and demanding radical reforms to our judicial system. We must be willing to challenge the status quo, to confront the powerful, and to fight for justice, no matter the cost. As our ancestors would say, a single stick cannot burn a fire. But together, each one of us, we can create a blaze of justice that will truly burn away corruption and injustice, so we can begin to enjoy our profession. We will launch, in accordance with Executive Order RNB number 2 of 2024, a nationwide campaign to expose judicial corruption and misconduct. We will use every tool at our disposal, including social media, traditional media, protests, and boycotts, to bring attention to this issue and to demand action. We will also establish an independent commission to investigate all complaints of judicial misconduct and provide recommendations for reform. This commission, a bar commission, will be composed of respected legal experts, civil society leaders, and ordinary citizens who are committed to justice and accountability. We are done waiting for a moribund Judicial Service Commission to remember us. So those who thought that by stopping us from sending our members to the Judicial Service Commission, we will stop implementing Executive Order RNB number 2 of 2024, woe unto you. The radical new bar is back on track, and there's nothing to stop this process. Furthermore, we will work with Parliament, and I will see the Speaker before Christmas, to ensure that we can pass legislation inspired by the radical new bar to strengthen judicial accountability and independence, and to improve advocates' revenue, resilience, and representation. We will push for laws that provide for greater transparency and oversight of the judiciary, greater independence of the legal profession, and above all else, laws that protect whistleblowers and complainants from retaliation. Here, let me submit that the Whistleblowers Protection Act of 2020 has a manifest error on it. In section 4 thereof, it is mentioned that these are the external authorities to which a whistleblower may make what they call a disclosure other than to your employer, an external disclosure. You know, the Uganda Law Society isn't listed there. They mention police, they mention the Human Rights Commission, they mention the IGG, they mention Parliament, and they don't mention the Uganda Law Society. We think this was an oversight, because if the Parliament had reconciled that bill with the Uganda Law Society Act, it would have noticed that in section 3D and section 3E, but section 3D particular, functions of the Uganda Law Society, we have an explicit duty to protect and assist members of the public in all matters touching on the law, the administration of the law, and so on and so forth. So, members of the public under the 1956 Uganda Law Society Act are invited to run to ULS House and to any of our branches and offices across the country to report matters concerning, contravention of law. So our clients truly fit the description of a whistleblower under Section 2010, yet they were denied whistleblower protection if they made their reports to the Uganda Society. I think that's a manifest error. I hope I'll convince the leader of the legislature to expedite that reform, because we are going to be the lead processor of whistleblower complaints in the new year, I can promise you. Colleagues, this is a call to arms, my fellow lawyers. We should not receive whistleblower complaints. We should not expect to receive whistleblowers from outside the bar. The first whistleblower complaints we need are from lawyers within the bar, about fellow lawyers and about judges and about fat cats in the public service. Let us rise up and demand justice. Let us be the radicals, the rebels, and the revolutionaries that our profession needs. Let us fight for a better tomorrow today. We owe it to ourselves, our clients, our families, the people of Uganda, to take a stand against judicial corruption and misconduct. We owe it to ourselves to reclaim our profession and restore the integrity of our judiciary. So let's march forward together. My colleagues, my friends, let us speak in one voice and fight for justice, accountability, and the rule of law. The time for cathartic drama is over. Let us create a judiciary that truly serves the people and not just the powerful and the corrupt. For most lawyers who had never experienced a second moment, you've now seen it. So don't wait for further examples of a bad judge. You have one. When elephants are silent, the grass will speak. Today, we, the lawyers, are the grass that will speak against injustice and demand a better future for our profession and our country. We can do this. We must do this. The time for timid whispers and polite complaints is over. It is time for radical action. I invite you to the beginning. Merry Christmas. Mr. Vice President, unless you have other duties for me, I have delivered the presidential address to the members, and I wish to resume my seat.
All right. Thank you very much, Mr. President. Again, I appreciate the members online and those who are here physically. The President has properly delivered his address, and I invite anyone who has a question, whoever has questions for the President concerning the address you've just had, please raise your questions. It could be physically, online. If there are any questions online, please.
Let's take some questions. Especially
let's take a few questions, and the President will answer your queries. Yeah, you have a question? Do you have a microphone? Okay, we'll take a question from here as we wait for members online. We have one question so far.
Yes.
Please, can you introduce yourself and you ask your question?
Zaina, no, is the question from you?
Yes.
Please come forward. Come forward for recognition. Come and share the presidential pulpit. We asked women to be sassy and to elbow men from pulpits.
Okay. You talked about the Bar Association. I just need more clarity on that because, yeah, I believe it's in the best interest, probably.
Hold on. The Bar and?
The Bar is it the Bar Association?
Yes. Well, Uganda Law Society is the National Bar Association. Yes. When we go outside at the IBA, we are called the National Bar Association for Uganda. So the IBA is the International Bar Association, and its members are national bar associations.
Saying you are going to constitute it, so probably supervise them.
Oh, you mean a bar commission?
Yeah,
a bar commission. Mm-hmm. Oh, yes. Let me clarify. It is within the mandate of an independent legal profession to utilize all its power, including tapping the resources of its members, the talent, the financial resources, the visions, the ambitions of the 5,800 members that we now have to participate in national affairs. And therefore, it is within our mandate to establish our own commission composed of lawyers and non-lawyers to address an issue of national significance. The issue that we must deal with today in terms of R&B, Executive Orders R&B number 2 and number 3 of 2024 is judicial corruption and judicial misconduct. It is a radical surgery of the judiciary. There has been this notion that only the Judicial Service Commission can do this for us. whereas we will support the process of composing the Judicial Service Commission, it doesn't mean that we will yield our power to investigate and bring repercussions to judges that don't keep within the straight and narrow path of the law. I hope I'm clear. Yes, accountability is not exclusive to the Judicial Service Commission. Judicial accountability is a function, a duty, and a right for all of us. And the bar must take leadership. We take leadership today through the measures we've issued and through other measures we're going to issue. But the commission will be our highest watermark, in the execution of executive orders, RNB number 2 of 2024. Yes, thank you for that question.
All right. Thank you, Mr. President. We have another question over there. Please introduce yourself and put your question across.
Yes, thank you so much, Mr. President, and thank you, honorable members of the Uganda Law Society. My name is Atabua Shamil. I hope I'm visible and you can see me. Yes, I am a victim of Justice Sekana's impunity. He has a habit where I had a matter which was allocated to Justice Baguma. He majestically walked to Justice Baguma's courtroom, stole the file, took it to his own courtroom, reallocated it to himself, and he has sat on it. We have written several letters to him. He does not respond, he simply ignores. To the extent that even now, opposing counsel has started writing letters to him, he does not fix the matter. When I did my investigation, I find out that Justice Sekana is protected by his best friend, the principal judge, Dr. Flavian Nzaija. Every Wednesday afternoon, they cozy up in Dr. Nzaija's office, and they eat their lunch and their meals, and they talk. To the extent that they even made a comment, oh, it's that one again, another Mabirizi. So that's what they now refer to us, that the so-called stereo litigants. Yet we are dying and struggling for looking for justice. So, Mr. President, on top of sanctioning Justice Sekana, I would like to request, if so, that you should also sanction the principal judge, Dr. Flavian Nzaija, who protects such judges, because the fish rots from the head. And right now, there's a rotten head who is Dr. Flavian Nzaija, with his assistant in crime, Musa Sekana. So please, Mr. President, can the Law Society also sanction for us the principal judge who has for so long protected the impunity that is Justice Sekana? Thank you so much.
Thank you very much, Shamil. A short answer to your question is that I agree with you. Judge Musa Sekana is a bully, and he's protected by a cowardly principal judge with whom they have a cozy relationship. We have received numerous whistleblower complaints about the principal judge, and we, as the bar, are processing a report about him. It shall be released in the new year and hopefully before the annual judges conference. We have the principal judge in our sights. I can guarantee you that. And we reported the principal judge to the Chief Justice when we met. I can tell you as much. So we are waiting to see what will be done. Reported, we hinted on it, I could say. But we are processing a formal report on the conduct of the principal judge since he occupied office. There are many reports across the country about his acts that undermine decisional independence of fellow judges. There's even judgments, you know. But we hope advocates who are victims and court users who are victims, just like you, use this forum to speak up more and come to us directly so that we have a solid case to present against the principal judge and prevent him from getting the promotion he so badly desires. Even if he gets it, we will not relent. You see, evidence does not rot. Yeah. radical surgery is going to make those people, expose those people completely. Yes, any questions from the...
All right. Thank you, Mr. President. I think let's first take one more question from the physical presence, then we take the ones online.
Yes. Adam, can you read the questions from Anna? Yeah. Or we have
Oh, sorry. Yeah, good afternoon to everyone. My question is not concerned with Justice Sekana, but it's concerned with the recent scenarios where we saw the Law Council denying Martha Karua a practicing certificate, which in turn made the Kenyan Law Society come out and issue a statement threatening cross-border practice by lawyers. So my question is, what is the Uganda Law Society doing to improve this relationship between Kenya and Uganda? Because for sure we have seen Ugandan lawyers going to Kenya and practicing in Kenya, and the denial of Martha Karua a practicing certificate to practice in Uganda is indeed an injustice, because Article 126 of the 1994 Constitution clearly talks about justice for everyone, and I see it is indeed this is failing the justice system. So what is the stand of the Uganda Law Society on this? Thank you.
Thank you very much. Colleague, if you could do us a favor and give us your full name.
Okay, my full names are Kasufa Edwin Tobias.
Kasifa Edwin.
Kasufa Edwin Tobias.
And you're an advocate?
Yes.
Yes. Okay. Thank you very much. Is it connected to this, or it's a different question? All right, Mr. Vice President, it's your call.
All right. Probably could also. Did he say it's the same as his?
Not as such. Okay, my concern is we are members of the East African Law Society. First. My name is Sentumbwe Yasin Munagomba. I'm an advocate. We are members of the East African Law Society. And now we are seeing Uganda Law Society acting quite independently of the other. I am asking Mr. President, under the Radical New Bar mandate, how does the East African Law Society come into our play? Because since it is our time, we want change. The East African Law Society, to which we are members, should be in bed with the Radical New Bar agenda. Lest we shall either say we withdraw membership from it if it does not heed to our immediate expectations. So maybe in your address to us, I am seeking that the East African Law Society is part and partial in our daily agenda as the Radical New Bar. Thank you.
Thank you very much, Yasin and Mr. Kasfa. I would like to assure you, colleagues, that the Radical New Bar leadership of the Uganda Law Society enjoys the most cordial relationships, both with the Law Society of Kenya and the East African Law Society. When the news, the sad and depressing news of the decision of the Law Council denying Honorable Martha Karua, Senior Counsel, special practicing certificate in terms of Section 18 of our Advocates Act reached me, at first I was nonchalant. I thought this is yet another joke, you know, from one of our institutions. I hadn't read the thing. I didn't even think they had made a decision. I thought these were comments. I thought they'll be making a decision later. But the first calls I received were from the Vice President of the Law Society of Kenya, Mr. Mwaura Kabata, urging me to not look at it as a national matter, but as a cross-border practice matter. He supported me with all the information I needed to understand the leadership call of duty in that moment, I was able to appreciate, for instance, that there are over 350 Ugandan advocates in Kenya, and they're not just enjoying temporary certificates of practice. They have full co-equal rights of practice like any other member. And they were the first to submit a mea culpa, a letter of forgive me for my country's sins, to the Law Society of Kenya. He shared with me a copy. And the fullness of the gravity of this situation began to hit me. I also received a call from the most recently elected president of the East Africa Law Society, Mr. Rama Abubakar, telling me that as the regional bar, they cannot move without a signal of the direction of the national bar. He urged me to take whatever time I needed, but I had to go on record and give direction as the leader of the National Bar Association in Uganda in response to that concern. And as for our position was issued in writing, we have a duty in terms of the IBA statutes and IBA standards for independence of the legal profession under Article 19 to be the primary center of support and cooperation for foreign lawyers who wish to practice in Uganda, whether temporarily or permanently. We have a duty to offer cooperation and assistance. So that duty binds whoever will hold this office. It binds the bar. Secondly, on studying the Law Council decision, I realized that they spoke of a special sitting. I thought it was a joke until that part, special sitting. And then I realized that under section 2 subsection 1D, I'm a member of the Law Council and hadn't been invited for this special sitting. Vice President, you can confirm. They have previously invited us, but on this particular one, there was no invitation. So it was malicious right from the beginning. And we made those points public. And had we been involved in the capacity I've spoken about, we would have said the bar is beholden to Article 19 of the IBA Standards for Legal Profession to provide cooperation and assistance. And what we saw from the Law Council position was neither cooperation nor assistance. It was anything but. I think the attitude, the vitriol against a distinguished female jurist by an organization led by 2 women was just too much. You know, I like to criticize Ugandan flimsy feminisms, but they were very much on display. Here were 2 women, Judge Mulyagonja and Christopher Navakoza, rubbishing off another woman who is far more distinguished than any of them. And that is how the girl child supports each other. By 2 women showcasing just how much they are in love and in bed with a dictator in Uganda for the sake of rising up in their careers. While a woman that has made a record of fighting dictators all her life, blocking her from coming to Uganda to, fight another dictator. So this was really bad. This was really bad, and they accused her. So I thought that our position is that the handling of the Martha Karua application was egregious. She's the victim of discrimination based on her origin and her political opinion. Under the IBA standards for independence of the legal profession, it is prohibited to associate an advocate with a political opinion or political cause of their client. But that's what the Law Council did, oblivious to IBA standards. So we have decided to take over the application. We have had an engagement with Honorable Martha Karua. She has visited us here, and she has requested formally for her Article 19 rights under the IBA standards. And we're working on submitting a fresh application, supporting her in submitting a fresh application with the views of the bar. Since the Law Council itself said that the criteria under Section 18 are open-ended, the only difference is that they looked for only obstructionist criteria instead of facilitative criteria. So we're going to warn them that actually that's not the law. Every administrative power, every statutory power must be exercised reasonably, fairly, and within limits that make, that align with logic. You can't use caprice to make decisions. A missing, spelling errors, which email you used, that's capricious. What is the substance? The substance is that there is a client who is entitled to a lawyer of his or her own choice in terms of Article 28, Sub-Article 3D of the 1995 Constitution. Whether the lawyer they choose is foreign or local is insignificant. It is expressly prohibited by Article 21, Sub-Article 1, Sub-Article 2 of the Constitution. Okay? So, the position of the Law Council that an advocate must have some sort of, a foreign advocate must have some kind of peculiar skill they bring over and above what we have in Uganda, it's a non-factor, and with respect to an error. So we're going to have those battles. We are happy that the council, resident council within the Uganda Law Society House is working on this. But we also need support from other lawyers who would like to work on that application. You can express your interest to our acting CEO. She will guide you accordingly. Yes. I hope you're seeing that helps. That helps. And the statements that the Law Society of Kenya and the East African Law Society that they wrote thereafter, you can see that they were affected positively by the position we took as the National Bar. We were able to cool emotions a bit, but it's actually a real war. It's a trade war. The Law Council kicked off, a trade war which can render so many Ugandans jobless. If all those people returned here, we wouldn't be able to, absorb them. With the law, is the Law Council a job creator? I don't think so.
All right. Thank you, Mr. President. Allow me take a few questions from the members online. Some of them are really comments, so I'll only pick out the questions. There's this one from Kagute Mazake that want our cases be dismissed. That's the first question from Kagute Mazake. And Mr. President, probably if you could address that member.
Oh, he's a member asking cases probably for Sekana.
Yes.
Well, Sekana is a bully. So your cases will be dismissed. But this is industrial action. Okay, industrial action is in the law. Okay, what's his name? Kagutema?
Yes, Mr. Kagute Mazake.
Mr. Kagute Mazake, you are protected. We are a workers' organization. We have declared industrial action against a bully in a position of management. That is our right. Now, to really show you that Sekana is defunct, he can't. If he dismisses your case, it will be because he can't understand the rights of the bar as a representative of workers. And when it has declared industrial action, that's a lawful action. And there can be no retaliation against workers for taking industrial action. But, as Stella Nyan says, bullies do what bullies do, but we shall deal with it legally. Okay? Yeah, so rest assured, what we are doing is industrial action, is in the law, and it's it behooves Judge Sekana to reflect on the essence of this action against him. Okay?
All right. Thank you, Mr. President. I hope, Mr. Zake, your concern has been addressed by the President satisfactorily. Mukisa Alex says, Mr. President, I request that you repeat the explanation clear, but I believe the explanation has been clear. I would think we don't have to go back into that. But there's the next question, President, from Nora Oaraga, that what recourse for clients of the bar who are the ultimate victims of judges with a propensity for doctrinal infidelity? That's from Nora Olaga. What recourse for clients of the bar who are the ultimate victims of judges with a propensity for doctrinal infidelity?
Nora would be pleased to know that as the radical new bar in the implementation of Executive Order RNB number 2 of 2024, we are going to launch a nationwide campaign of civic education, legal education that will make the options of the citizen and the court user well known. The truth of the matter is that this is the authority, this is a function, this is a duty of the Judicial Service Commission, which has been ignored since the foundation of the Judicial Service Commission. So many court users do not know and what to do when they are victims of judicial misconduct, judicial corruption, judicial infidelity, And there is this mantra, appeal, apply for review, follow the law, send a complaint to the Judicial Service Commission, as if that's the only, sources of recourse. And those processes have been defanged by the high priests and Pharisees that run the judiciary. They have eroded any public trust in them. No one believes in a complaint to the Judicial Service Commission. We've just heard from Shamil anymore. They just pile dust. Those who appeal, give up, because there's the cancer of delayed justice in the appellate courts has rendered our appellate justice system almost inexistent to the poorest of the poor. It's available for only the most privileged. So what options does Nora have? Nora, we shall lead from the front. We shall tell you that you have more options than those which are traditionally spoken of by the elites, those which are now, those decorum options. We're going to break, we have broken the grip of decorum on citizens' rights in the judiciary. We're going to release citizens into further actions for judicial accountability, including boycotts, protests, social media action, all tools at our disposal. We're going to protect you. But the most important weapon you have now is a whistleblower complaint presented to the Radical New Bar leadership through any of the forums we will avail you. We will own up your concerns and give them the pride of place, the pulpit of the bar, and call out those judges individually with Nora standing next to me. Then she won't be ignored. So all victims that get the gumption to reach our door, they will get to enjoy the spotlight that the bar presidency can give their complaints. That we assure them. And Nora is welcome to visit us, just like Martha Karua did, just like the students of Makerere University, when they were here, they got access. This platform works for for so many, and we shall give it to so many. Past leaders denied it to you, Nora. The RNBA leadership will give it to you, even tomorrow if you so wish it. You can come and call out your demo it using this platform at ULS House. You will get some peace and justice. And I believe even fairer judicial outcomes moving forward.
Thank you, Mr. President. And now I have Timothy Mugumya has 3 questions. The first one being, will there be EGM? And if so, what will be the issue to deliberate on apart from Justice Sekana's matters? The second one, what's the ULS's position on the interim ruling by Justice Sekana? Is it in effect until set aside, as would be the case? And if so, does that mean the council is comprised as it was after the AGM? And the third one, which is his last question, were all internal remedies exhausted before the judicial reviews, before Justice Sekana, that led to the recent interim ruling halting the EGM, or there were internal avenues, and if so, did the court have locus? Mr. President, those are the 3 questions from Mr. Timothy Mugumya.
Timothy Mugumya should be our member, I believe.
Yes, he should be.
Well, Timothy, we have received advice from counsel to the bar, Mr. Jude Biamukama, that the order of 13th December is so extensive and categorical, it prohibits us from conducting any step in implementing the council decision of 24th November 2024, including the holding of an EGM that had been scheduled for today at Imperial Beach Resort, and conducting elections for our Judicial Service Commission nominees, either today or on any other date. And it purports to restore some council members to positions which those very council members abandoned voluntarily and have never recanted, and none of them has applied to court for restitution or reinstatement. So this is the advice we have received from counsel to the bar. Counsel to the bar has also informed us that the bar faces yet another threat, namely a pre-existing gag order issued in February in the case of Brian Kirima, another member of ours, in which the same judge, Musa Sekana, purports to prohibit any member of the bar from exercising their democratic rights under Section 16 of the ULS Act. That is to requisition a general meeting until he decides as the judge that you can do so. So the bar is blocked under both Section 15 and Section 16 from congregating as an assembly of the whole profession by one judge, Musa Sekana. What is the position of the bar? The position of the bar has been to instruct counsel to put all this before an appellate court, so that a new branch of the judiciary, a new level of the judiciary, can understand the shenanigans of judicial overreach that have almost suffocated the legal profession at the High Court, and in particular the Civil Division, and in particular under the grip of one judge, Musa Sekana, to whom these cases against the bar seem to go. You know, we will in time provide Counsel Jude personally to speak about the processes and prospects of that appellate process which he has started. Counsel to the bar has also informed us that none of these applications truly pass the threshold of being legitimate complaints, being legitimately ripe before a court of law. They're all premature and they're all misconceived and they ought to have been struck out. But we are now wiser. We know that Judge Musa Sekana is part of a clique and a cabal that wishes to see the bar suffocated and erased from its statutory mandate, its true place in the nation, for whatever elitist reasons they have. And so he really shouldn't have been the right person to hear these cases, shouldn't be the right person to hear these cases moving forward anyway. But that's why these applications received exaggerated judicial attention. What was the third concern of his?
The third concern, Mr. President, was, just a second, were all internal remedies exhausted?
I think I've tried to touch that one.
Yeah.
No, they weren't. The most important internal remedy at the bar is to invite the whole membership. Get 15 signatures and requisition the whole membership, auspices of council. Just summon the whole membership and you get the decision of the committee of the whole membership. That hasn't been done by any of those people. They've just rushed to court to, hamstring the bar on the hope that they can find a favorite judge that will have mercy on their concerns, which they seem to have gotten for now. So that's the situation. For those whose matters are election related, the election rules, the Uganda Law Society elections regulations, establish an independent elections committee which deals with complaints. And if you're not satisfied with those the way those complaints have been resolved, the same rules establish an election appeals committee to which you can take your grievance before you enter a court of law. We haven't seen anybody demand of us as council or the committee, the appeals committee, a reason to sit, a reason to offer them a forum to sit, to constitute a sitting of the election appeals committee. So again, we don't know where the judge really grabbed jurisdiction to insert himself in the internal affairs of the bar. Yet the same judge has previously been a staunch defender of the internal democratic rights of other organizations. So that suspicion is what confirms his bias, his disregard for law, and quite frankly, his incompetence. And that's the reason why we've spotlighted him as a microcosm of the cancer that afflicts the Uganda judiciary.
Right. I think, Mr. President, thank you very much. We'll allow, I think, 1 or 2 questions from the members present before I go back to the online questions. You still have another question? Can you please get up and assist her with the microphone, please?
Whereas today's conference was mostly about the unfair ruling of Justice Sekana, I would like to point out that there are other issues which affect the proper administration of justice. and which have been really paining us. For example, the failure of judicial officers to turn up when they fix cases, and yet they don't notify us. And then the fact that in most cases they make lawyers and litigants wait for a long time to be worked upon. I must say they are good judicial officers, like Mr. President said, but the likes of those who do such things really spoil everything. So as we think about, I'm hoping we can find a way of handling almost everything that affects us as we
Councillor
pursue.
Zaina, come and stand with me. I want to answer this question with you.
I'm still also talking, though, Mr. President.
Come here. Share the pulpit with me. Continue. Yes.
Yeah, and probably this will be a wake-up call on the judicial. Probably this will be a wake-up call on the judicial officers who really undermine lawyers, like they act as gods in their courts. Like I have an experience in Machi India Court. I was before some registrar around December last year. It was a very horrible experience for me. There was a tendency in Machi India Court of arresting people who present forged death certificates. I don't work in NIRA, and of course I couldn't have been the one who processed the certificate in question. But the judicial officer, first of all, she asked for my PC, as in I did not have it, but I requested for time to present it to her. She didn't allow me the time. Even she didn't give me audience, but she called on me, a police officer, a female one, who almost arrested me. Like they got me around 3 p.m. and I was only released on bond like at 10 in the night. It was so much horrible, and I really had no say before her. I can never forget that.
Sorry. That's classic intimidation. That's classic intimidation, dear. And I want to answer you while you're still here. Today, it's not just about Justice Sekana. We only stress him because what his ruling means, the full implications of his ruling, is that it denies the entire legal profession an organized voice, an organized forum, to be able to think through and process resolutions that can fundamentally improve judicial outcomes for everyone else in one swoop. Do you understand that?
Yes.
His ruling is a blow at the heart of the administration of justice. And he knows that. And he's working in cahoots with a group of people that have benefited from a captured bar previously. For instance, he was appointed by a Judicial Service Commission that was improperly composed. It had friends of friends receiving his application. Justice Sekana was corrupt at the bar and is corrupt at the bench. And he knows it. The evidence is out there. His display alone. But what has kept him there? Oh, the members representing us at the Judicial Service Commission have been masqueraders. They let him in and they've kept him there. The people we are trying to send there have all in unison criticized his conduct. Did you see the difference? So He's a microcosm of all that is evil at the bar, on the bench. In fact, at the bar as well. So you need to understand that that magistrate in Machindia,
She was a registrar.
oh yeah, that judicial officer in Machindia picks a signal from the Sekanas of this world. If Sekana can intimidate attorneys at the High Court Civil Division, I probably can do the same. Do you understand? So we must as well focus on smashing the heads of snakes like Sekana at the Civil Division. Head of the Civil Division. Smash that head such that these other judicial officers understand the consequences of social accountability as an alternative and a complement to Judicial Service Commission processes. Am I clear?
Yes,
Yeah.
can I add something small? Actually, I lodged a complaint with the Judicial Service Commission because I was really furious. That was in December, but up to date, it hasn't been handled.
They haven't even replied to you, perhaps. Have they?
They did last month.
After,
They told me, yeah.
What was the period between you reporting and them replying?
I reported in December, then the person telling me to write my statement, like, called me up last month.
It's 11 months. So these people really take us for fools in our own country. So you can understand why people like Justice Sekana don't want the Judicial Service Commission to have proper leadership. To maintain such poor judicial culture and to cause such harm and trauma to court users. These events are common and they are perpetrated by the silence of lawyers and court users. I thank you and I celebrate you, Zaina, for speaking up. It's hard. You can imagine the tears you have. Imagine ours, who have been in practice for nearly 15 years now. And when we tell people that this is a moment to bang the table and crush dimwits and dead wood, and we bring to the ballot a resounding victory, they act surprised that lawyers didn't know exactly how to vote or why they voted. There's just too much trauma out there. So, Zaina, I just want you to know exactly why we're meeting today. The bar, the rights of the bar, not individual lawyers, the rights of the bar are the last defense you have against such trauma. It can't be treated by doctors, it can't be treated by politicians, only lawyers meeting in general meeting to perform the rights secured for them under the IBA standards for a legal profession, under the UN basic principles for the role of lawyers. Those two mandate instruments have never received spotlight in Ugandan jurisprudence. They have never received spotlight on this pulpit. They have never received spotlight in our national laws. That's why our laws haven't been amended. Because if they are to be amended, the guiding stars are those two instruments. And those instruments ask us to speak unreservedly against judicial misconduct and judicial corruption whenever we confront it, including at the steps of court immediately after you've faced it. You have the right to address the press immediately there. But many advocates haven't done this. They haven't been raised in that tradition. That's why our campaign call was, bring only bad manners, because good manners has had its run. And it has brought us here. It's time for bad manners. Ladies, especially. Look at what decorum did to Zaina. She's almost broken, recalling this trauma by another woman. And you have this decorum brigade from the Female Lawyers Network erasing your trauma. Never talking about your working conditions. Their favorite subject is how to whip up force victim weaponize gender for you to get into top positions. What if you just want to be an ordinary woman doing ordinary things and enjoying an ordinary life? Who protects you? Okay? The idea that for women at the bar, you must be extraordinary. You must receive an appointment first before you can be seen to enjoy rights that are obvious and ordinary. It's a shameful idea, and you must be the first to call it out. These women that like celebrating women for just being women, they are the decorum brigade for corruption, for incompetence. And for the decay and decadence we are convened about today. So I thank you, Zaina, for sharing that story. And I promise you, in the new year, our business is to give this platform to many people like you, many courageous lawyers like you, to show up at these condemnation rituals when we summon them and condemn those who have hurt them by name. Take photos. We will pay the cost of making billboards out of them. This is the radical new bar. Mr. Vice President, any other questions?
Thank you, Mr. President. And just to add on your voice, I see quite a number of messages on the chat. Members online who are feeling your pain, Zaina, and I believe most of them are thanking you for coming out and speaking out, because there's a feeling that most people die quietly, remain silent, and suffer due to decorum. So that's what I get. That's that's what I see from the group. Now, Mr. President, this online question, I think this might not be a member because of the nature of question, but I'll put it across so that you can answer, so that they don't feel they're left out. This is Moses Wali. He says, can Sekana be impeached? That would be the quickest remedy. And how must it be done legally, so that you guys push for that as a faster remedy? So this is
I
Moses
thank
Wali.
Mr. Moses Wali. You know, we must celebrate how non-members think. We must celebrate radical ideas when we face them. The total solution to Sekana and Sekanaism is impeachment. What blocks it is thinking like a member. And what does it mean to think like a member of the Law Society? Is to accord Sekana courtesy and collegiality in the face of every injustice he does. We offer him courtesy and collegiality as a fellow advocate who is being elevated to the judge and who does important work for others. Maybe he had a bad day with me, and so on and so forth. But non-members see through these dimwits right off the bat. They see through them. They are better judges of character because they don't wear decorum blinkers. I would like to assure Mr. Moses Wali, the reason why we can't impeach Judge Sekana today is because advocates will not give us the evidence sufficient for us to invoke the power to impeach him. Otherwise, the day we get that evidence, We present it to cabinet, and the cabinet will exactly do what cabinet has done before. It recalls a judge immediately. It starts the process. The process of going through Judicial Service Commission is just too hectic. They protect each other. I mean, there is no Judicial Service Commission. We know that. We've had this. So the Judicial Service Commission is the sum of the integrity of the members there. If the sum total of the integrity of the members there is 0, it exists in name only. So, Mr. Wali is right. We should aim at impeaching, and we hope in these 30 days we get impeachment quality evidence, such that on the 15th of January we have a case for impeachment. We make it publicly and in every other forum available to us. So, Mr. Wali, the obstacles to impeachment, you won't believe it, are fellow lawyers. They are the ones who have witnessed and condoned judicial misconduct by the seconders of our crisis-laden judiciary.
Right. Thank you, Mr. President. So, Wali, you can be rest assured that the bar will do something about that as long as you have evidence, just like it has been stated by the President. Now, Mr. President, this is more of a comment, but I think we can't go without mentioning it because it also touches the core of what we're discussing, independence of the judiciary. And this is from Musore Frank, who says that it's a narration that yesterday we were at Impigi court, and when a matter was called for hearing, a lawyer representing URSB issued a mere letter to the Honorable Judge informing him that a complaint was lodged with the principal judge and the matter was adjourned prematurely. So I felt much as it's not a question per se, it touches issues that we've been talking about, and I believe this member probably wanted to put it out across, and I think from what you've discussed, you touched a bit of independence of the judiciary.
Yes.
And the untouchables, and I think what is of concern is that a mere letter or a complaint, a judicial officer can rely on a complaint to the principal judge to adjourn a matter which is before them.
Yes. In human rights, we call it horizontal and vertical application. So, the judge, that judicial officer feels that accountability to the principal judge is of a greater moment than accountability to a court user. Yet Article 126 of the Constitution on judicial power says you derive it from the people. It doesn't mention the principal judge. It says even the little power the principal judge has, he or she derives it from the people. That is why Article 127 of the Constitution has never been implemented. Participation of the people in administration of justice. Why are our people locked out? Why are our people erased and minimized and diminished in the process of administration of justice? It's a culture. It's a colonial culture. That's a call to decolonization right there. Why did the judge undermine me, who was before them, and choose to attend to a careerist threat that, somebody has taken me to the principal judge, so I should halt all business? That's what we call doctrinal infidelity, and it's common. But we need to start to have a way of bringing exposure, bringing light to these, these concerns, crowdsourcing them, managing them digitally, and making reports. Our rule of law reporting system has lost bite. This is the digital age. By the time we make a quarterly report, what we are talking about, everybody knows on social media. They've probably even moved on. So we need to start to look in the specific areas where trauma itself prevents stories from getting the spotlight of a rule of law report, of a ULS report. We need to encourage our colleagues, our court users. We need to bring our tools of accountability to them. And that's why we are making this bond with members. The bench, we are making them aware that next year, be ready to see us on the road in a van with a mkalakasa, asking people to bring complaints and lived experiences about named judicial officers, whether they are in that duty station or they have since left. I will not disclose exactly how we're going to do it, but I can assure you, we're going to use the power of the 15 law schools that we have. Those students are hungry for a change, and they've been shaken to learn that the people they look up to are not really model examples for ethics and integrity. The president of the bar says they are dimwits. They are dead wood. They are cancerous material in the body of justice. So we may not have the audience and favor of the seniors who caused this, but we are grateful for the audience and favor of those for whom the year 2060 will mean a lot if we get it right today. Mr. Vice President.
All right. Thank you, Mr. President. I have two questions from Ian Katebe. He's an advocate. And I think this, I'll read it together with some other questions. I think we can answer them at the same time. I think it touches the Judicial Service Commission and is asking, is it prudent and proper for the judiciary to employ fresh graduates from LDC as magistrates and leave out experienced advocates, as this compromises quality of judicial officers? And you also ask a second one, that is it possible for an audit for the last appointments of judicial officers who are recently appointed? Now, President, this is more of a comment, but also reads into this. That judiciary is a problem even to its own. Imagine deploying a G1 while there's another without a transfer. Would such judicial officer die of depression? So, Mr. President, that one was from Betty, just one name, Betty. But those two questions of Ian Katebe, I think, can be merged with this comment from Betty.
I would like to start by inviting us to recognize the service of our deceased magistrate, Her Worship Marion Mangeni, who was buried in Busia last Friday. Maybe we can have a moment of silence, a minute of silence, before we answer this question. Mr. Vice President, on Wednesday, I represented the bar, the Requiem Mass for the deceased magistrate, Mangeni. I apologize, I arrived late, but I arrived just in time to listen to the remarks of the widower, His Worship, Tom
Paul? Matiama.
Matia? You
Paul.
got it right, Mr.
Yeah.
Vice President.
Matiama Paul, I think.
Tom Matiama Paul, yes, Matiama Paul. Oh boy, wasn't he articulate? Even in grief, He invited us into what killed his wife. Abuse of power, he said, inside the judiciary. He accused specifically the system and the lords in that system that pushed his dear sweetheart, to quote, into depression. Not only did the system in which he is an employee deny her any promotion in 12 years of dedicated service, it embarrassed her by promoting him ahead of her. Yet, they had, I think they had shared the entry year, swearing in together. And by his own admission, she had much better craft, much better discipline, much better heart and desire. But the system said, you should be chief magistrate, you should stay where you are. And secondly, he accused specifically her supervisor who wrote this damning report about her. And she struggled to get it off the books. But in that time, she was bypassed several times by others. Apparently, they call them patients. We were given a glimpse of employment working conditions within the judiciary, especially the lower bench, by these remarks. The eulogy, the obituary of His Worship, Matiama Paul. I don't know. I am against ageism personally. I think people can be brilliant and competent at any age. Fresh from school, people can find their marker at any point in their life. And I think age shouldn't be the concern. The number of years shouldn't be the concern. If the ethics, the integrity, the specifications are right, when one is recruited into the judiciary, they should be subjected, they should be offered a thorough orientation that permits them to understand judicial service. Because that's what they call it. I think under the administration of the Judiciary Act, it's now called the Judiciary Service. To understand the nuance in judiciary service as opposed to public service, as opposed to private sector, as opposed to other branches of government service. The judiciary service is about, accountability to the people. You're going to make decisions that have real impacts on their lives. And within the judiciary, you'll find these rotten tomatoes that will invite you into a different culture. Not keeping time, loading over court users, intimidating them, showing them judicial power, and so on and so forth. Simply because there's a dormant Judicial Service Commission that doesn't check, doesn't investigate. It leaves you to be a lord, to be the law unto yourself. Well, some of these judicial officers, when I was still very much an active practitioner, I would enter court and I would see people create order. One clerk actually told me that So I had this view that the court was very organized, things move fast. Then one clerk said, no, we do this for you because you are Mr. Accountability. But when you go out, if we return to our normal order. So it taught me something, It taught me something. So for me, I think the judiciary is not so much about its own members, but also us, its heavy duty users. What demands do we make of it? You've heard from your seniors, up to date, they make more of decorum demands from the judiciary and its members than justice demands. That's why there's delayed justice, and they still call these people honorables. You haven't seen a report of the senior counsel bar. I think we should write an executive order sending them home. Because they have not begun to contemplate on the role they have in creating a better judiciary. They're the senior counsel bar. For what purpose? For what purpose? If not to be guardians of integrity, of ethics, of the finest traditions of both the bench and the bar. In Kenya, we see Senior Counsel Aminwa and others, Senior Counsel Abdullahi, Ahmed Nasil, taking great risks to hold the judiciary accountable, to use the title Senior Counsel. But I guess that tells you their complicity in crimes against the people with the current crop and past crop of judicial officers. They lack integrity. In the new year, and I hope we will get sufficient number of people crying out to expose them as well. So I think that's what has shaped our current judiciary. We need you younger lawyers, Betty and others, to help us and understand actually that younger lawyers joining the judiciary may be what cures it. They shouldn't be blamed, for taking up this duty. They must be protected against negative traditions, destructive traditions in the judiciary. What was that second thing about? Yeah, the audit business. Well, I think that question preempts our report, our response to the judicial report. But I can give some highlights, if you permit me, Vice President. Yeah, the judiciary has always avoided an audit by claiming that they're independent and they will audit themselves. They have created various units, which we are going to critique and make a report to be released for your discussion next year. But they have promised us, the latest promise in the 22nd or 23rd Judges Conference, they promised, the 23rd Judges Conference in the year 2022, they promised that the Judiciary Performance Evaluation Tool was ready and they would launch it. And it has so wonderful features, including being marked by court users on the day, case by case. And all this data is aggregated. Well, anybody, have you had any high-ranking judicial officer mention the performance evaluation tool again since 2022? No. But this is a ritual they do. So they last put focus on the performance evaluation tool 10 years ago. And before that, 10 years ago, every 10 years they say, for the last 10 years we've been tweaking this report, this tool. It's now ready for launch. And they just never launch it. But I do remember when I was at university, the Auditor General wanted to audit each judicial officer individually. And the new Chief Justice then, Chief Justice Odoki, made a huge case saying that would violate Article 128. We are self-accounting, so we should also be self-auditing. I guess that was the point he made. But I think so much water has passed under the bridge. We now know that the decision in Gladys Nachibule, Attorney General versus Gladys Nachibule, that clear jurisprudence by my Lady Justice Tibatemwa changes all past ideas about judicial accountability and judicial audits. Judges are not immune from any form of accountability. They will definitely squeal that it sounds like, smells like, tastes like an erosion of their independence. But that judgment warns them that accountability is accountability. It's unwelcome, undesirable, but of great value. And I think we should design social audits for people and put them in their power as the radical new bar, as they await the performance tool, which will never come.
Right. Thank you, Mr. President. Now, there are quite a number of issues, but I'll pick 3 questions. I'm sorry I might not be able to handle all of them. Others are more comments, and time has really moved. Now, the 3 questions are specific in particular areas. I'll begin with one to do with what we actually been discussing. And Karibwije is asking, how will the bar participate in the recently advertised recruitment of the Deputy Chief Justice in line with Executive Order Number 2? There's only one name, Karibwije.
Well, I don't know. I think I'm only able to say that Executive Order R&B Number 2 requires us to hamstring the Judicial Service Commission until we have representation. The consensus at the bar is to audit past recruitments, question ongoing recruitments, examine them thoroughly and ensure that they pass the test of the executive order. So we are in meetings with council and we need volunteers from amongst you. Don't just stop at asking questions. It seems like Mr. Karibwije has read the executive order R&B number 2.
Yes.
So Mr. Karibwije, I am very restricted in what I can say because there are ongoing conversations in council and with our council on that issue. But I can only invite you to come privately and be a part of that conversation. As a member, you should know exactly what we are thinking and haven't yet made public.
Right. Thank you, President. Now, this wasn't part of the other 3, but I feel we shouldn't leave it out. This is Mr. Richard Okaranyi.
Yes.
Is asking, Mr. President, what is our plan of action against the recommendation of Judicial Service Commission for removal of Justice Chisache from office? And secondly, is a poorly written judgment disregarding basic and settled principles of law by a judge evidence of incompetence? So Richard Okaranyi has those 2 questions, which are not part of the 3 I intended to ask. But
let me first attend the first one regarding Justice Chisache.
All right.
Yeah. It is our policy now, as the bar, not to offer running commentary on cases or proceedings which we believe to be in the capable hands of any of our members, unless invited by that member to provide specific forms of intervention. The case regarding Justice his search is in the capable hands of Mr. Walubiri and the law firm KBW. And we can only provide an observer mission for the time being, unless otherwise specifically invited by the councils on board. If they face challenges to do with fairness, transparency, and integrity of those proceedings, they are entitled to call upon the bar, services of the bar in terms of Section 3, subsection C of the Advocates Act, our duty to represent, protect, and assist members of the legal profession. They're entitled to call upon, and other members of the public also are entitled to let us know if there's cause for us to intervene in terms of Section 3D of the Advocates of the Uganda Society Act, duty to protect and assist the public in respect of that matter. But as for now, that's the position until we know better. We are grateful for Council making a status report known about that case. We are studying the status report, and hopefully in the new year, we shall have a position of the bar as well. Since the Council has done its Council on the case has done its part, he has made public a status report regarding that case, and we now have equal rights with any other member of the public to analyze that report and find a point of entry that is consistent with our mandate. Yeah.
Right, thank you, President. I want to think the second question is really obvious. I don't think it will take much time. He's asking whether a poorly written judgment disregarding basic and settled principles of law by a judge, evidence of incompetence. And that's the same person, Mr. Richard Okarani. So I want to believe, really, Mr. President, I don't know what you say is maybe too.
It's the common cry now at the bar, quality of judicial outcomes, and that is now where we are. Poorly written judgments that offend, the office of, that offend judicial office, simply state. What would be the solution? Is it an appeal or removal of that officer? Our position is simple. Listen to such calls. This may be specific to Justice Sekana. Don't ignore it. Go to Yuli, talk amongst yourselves, give us similar examples. Because Justice Sekana is fond of writing verbiage, copy and paste things there, and it's just with premeditated decisions. It looks like 18 pages, but in truth it's just one page. The rest is utter nonsense. You repeat pleadings and then you repeat things. There's no investment of judicial oil in any of these results. We have to start to call out this. At the Requiem Mass, Justice Chirawire told me that as the ICT committee, they have finally, well, this is a promise he has said before, but I don't know what finally means in the judiciary when they promise a reform. But he says, finally, we are going to launch a standardized judgment writing tool. Well, let's wait for February and see if that will be the case. But Mr. Okalani, I am as anxious as you are for this so-called finally. The judiciary is ready to launch a standardized judgment writing tool that will rid us of that menace.
Right. Thank you, Mr. President. Now, I know you've already talked about the Law Council, specifically in respect to Martha Karwa's issue, but I've seen so many questions about whether the RNB has a plan to address or to handle the issue of inefficiency in the law council, specifically to do with delayed enrollment. All the complaints say they take long to handle these applications and people are delayed to do an enrollment. So there are quite many questions, but they're all asking the same thing, whether we have a plan to handle some of those institutional issues with the law council.
Yes. The thing about delay for enrollment at law council is that these questions tend to be framed as individual appeals for specific relief, tied to an individual. Myself, get me out of this, help me jump the queue. I'm tired of waiting. I'm traumatized by these delays. And our position with all those who look at it as a specific individual situation is that it defeats the purpose of the power of the bar. Only a person who doesn't understand the meaning and significance of this pulpit can concern themselves with the individual case. It is our position as the Radical New Bar under Program 1, independence of the legal profession, to end the fallacy that the law council has any power, any duty, any right to conduct an enrollment exercise for an advocate. Entry into the legal profession is the power, the right of the legal profession. Admission into the bar should be conducted by the Bar Association. Our Members' Affairs Department should be conducting enrollment. That's it. Should be conducting admission into the bar. So the problem now we have is much of those people don't care about the doctrinal fidelity. And so they may not be willing to understand that we have to win this war once and for all, doctrinally, institutionally, and effectively through a realignment of roles. There are many roles at the law council that belong at the law society. Enrollment is just one of them. Discipline is the other. Legal education and training is the other. All those are roles for an independent legal profession. Okay? So, yes, we have a plan, and we have a radical plan in line with our R&B Vision 2060. We seek to abolish the law council in its current composition. Remove from it powers, duties, and functions that belong to the bar, that the bar can exercise on its own in terms of its self-regulatory framework, guaranteed under the Constitution and international statutes, international treaties, international documents, peer practice. This paternalism that we need a law council to scrutinize your application to enter the legal profession. Come on, we've argued this point before. Well, lawyers are dangerous, but they're not more dangerous than drivers, bus drivers, truck drivers. Getting a driving permit is a much simpler process than getting passport. You know the meaning of a passport. But the chief passport officer can process a passport for you even in express. Not because they are reckless, but because they have understood their system and they respect the documents others provide. Law council asked Martha Karua to bring P1 documents, you can imagine. What do you want with her? She is senior counsel. Why do you need academic qualifications, whether she which school she went to for LLB. How is that consequential to law council's decision making? Are you following? Yeah, so that's our position. We shall declare it sometime in the new year, and we shall invite all those who are currently victims of the blockade, but also colleagues in the profession, because this would have changed a long time ago if members in the profession understood the independence of the legal profession. There's so little awareness of independence of the legal profession and the full meaning. Only a few advocates send their president authorities on the full meaning. Many advocates are coming to repentance. I didn't understand what you meant. I have seen this case. Even this is our power. Even that is our power. So I feel that we need more of those voices asking not for what they can get now, but what should end now. There should be a total rejection of law council processing enrollment, a total rejection. And that rejection must be taken to the rightful places, namely HE, the president, and parliament. They have the power to do something immediately, more than the bar. As the bar, we shall bang the table and educate and use other tools I'm not at liberty to discuss now. But that's our position. The thing about it is, if you told that fellow gentleman, that person, that our answer is abolish the law council, they may not truly understand what we mean. But we shall explain it in the new year.
All right, thank you, Mr. President. Now the last two. This is from Katoto Msime. I feel this has been discussed and talked about, but he says
that's the twin.
Yes, Katoto Msime, the twin. He says talk about the delayed judgment from the Supreme Court by Chief Justice in the Honorable Kawas Guruka case. We need to do radical surgery to the CJ as well. I feel you've several discussed this.
We have.
Several times. I don't know.
Mr. Kato, we have. Wow, the CJ is a unique administrator in the sense that he invited us and said enough banging has been done. I am honestly, I have heard the cry. Give me a benefit of doubt. So we are at that point, sir. Not because we can't bang, not because what, but because the CJ was responsive to the banging. The person speaking has banged in many articles. The most recent being that the Supreme Court has unknowing dollar problem. It's not like the judicial accountability is a vain concept. So we've really banged. We boycotted his new lawyer last year, and definitely we will boycott his new lawyer. I saw him advertising it very early, knowing that after all he's hearing boycott. He wants to be sure that. But we'll see. I'm an optimist. I think the people of Uganda have joined us, but I think Kato makes the point we should never stop talking about this because we don't know the reasons why it's delayed, so we should never stop. I'm grateful that the president has joined this conversation as well. So it's now alive again. And as I said before, just last week on NTV, any further delay can only impeach the CJ and turn him into a politician. And those are fates I wish you would want to avoid.
During the Northern Bar activities,
yes,
he actually reaffirmed the same and said that he's open to discussion. Should we have anything we need to put across, his door is open to the bar, to the society, and to you, the president. Now, like I said, there's so many questions, but I feel others have been tackled because they're more specific. Talking about acting judges, talking about, I see it all goes to Judicial Service Commission. But Mr. President, with your permission, I wanted us to handle this last for two reasons. This person who asked seems to be, say, human rights defender on behalf of the public, and it touches also the office of both the judiciary and the office of the Attorney General. And it's a bit extensive. He's saying this is Kaiga Mudu Yisito, human rights defender from Greater Masaka, working with a regional CSO network. It's called COTFON, Community Transformation Foundation Network. That for so long, people affected by the East African crude oil pipeline have been sued by government of Uganda through Attorney General, starting with those in Hoima in December 2023, and later 80 people affected by the same ECOP in Masaka region on 1st October 2024 at Masaka High Court, and all rushed rulings were in Attorney General's favor to demolish property without fair compensation. And when human rights organizations like COTFON and human rights defenders step in to provide legal support, we are being intimidated through use of security agencies, etc. How can the bar support these marginalized people to get justice through superior courts in Uganda? We also welcome the opportunity from the bar to visit these violated people or visiting your office. Thanks. So that is from Kainga Mudu Yisito.
Yeah, I thank Mr. Kaiga for raising this issue, and it's an appropriate point at which we can end because it takes us back to the categorical mandate members gave us to fight for independence of the legal profession, clean up the judiciary, and remove systemic bottlenecks that affect advocates' revenue, resilience, and representation. The truth of the matter is that the leadership of the bar previously did not appreciate the harm of misconduct in the office of the Attorney General and give it appropriate spotlight in response in the public interest in terms of Section 3, subsection D and 3, subsection E of the Uganda Law Society Act. Our duty to protect and assist the public and to advise and assist the government and the courts in response to people's concerns about how the law is administered. As a matter of fact, we know that our predecessors rejected a requisition for an extraordinary general meeting to discuss the patient zero case in Hoima, where the Attorney General had, in cahoots with the resident judge there, initiated proceedings against this dead families, clans, and people he can't find, and gotten judgment against them in a record 4 days, and received an eviction order against every known rule for fairness, for dignity, and for equality in the administration of law, including even specific requirements, UN standards which were adopted, I think, in the case of James Muhindo versus Attorney General, about what the government and any other person who wants to do an eviction must follow. None of those, precedents were followed. So what are rules for if the government won't follow them? We thought this was a rule of law matter for which we needed to unite as the bar and discuss in an extraordinary general meeting. The Attorney General is the one who took out pleadings that time to challenge and obstruct the holding of an extraordinary general meeting of the bar to discuss that issue. And after that was done, they got momentum to destroy further livelihoods across the pathway of the East African crude oil pipeline. So these things are connected. We can block, obstruct, suffocate the National Bar Association so that it is unable to organize a response in defense of project affected persons for a massive initiative like ECOP. That leaves individual lawyers having no other capacity but their own law firms, and tip the scales further by adding intimidation. If civic organizations try to come into this process and basically use the law as a veneer for legality and legitimacy of what is entirely illegal and illegitimate. This is classic injustice, orchestrated by the chief law officer and endorsed by a judge of the High Court, recruited through an improperly composed Judicial Service Commission. This is the morass of injustice in which you are invited to practice law with decorum and dignity and courtesy and expect to make a living. The truth of the matter is that we are aware. I think it should give Mr. What's his name? Mr. Yeah, I should give the gentleman from Budu a little solace that the Radical New Bar is aware, and one of our first initiatives here was to establish our capacity internally to be able to respond to significant scenarios that surpass the capacity of our individual members. How can we complement the bar in high profile, high intensity, mass victim situations? I was informed that we can't, based on existing capacities. All our existing capacity is tied to projects that did not conceive injustice in that format. Injustice was conceived as private and personal and individual. And we have to reorient the bar and its existing donor pool to appreciate that kind of injustice. And hopefully they will accept to expand their gift, their donations, or we have to find a whole new suite of donors and partners that will permit us to engage in more flexibly in social justice. But until then, we can't just wallow in lamentations. We have to arrange our existing resources, and the most available is talent at the bar. So some point in the new year, we shall launch something on the World Social Justice Day, February 20th, or in the run-up to that, consistent with what we've learned from those unserved needs. Yeah, I think the gentleman from Budu should not entirely give up. Democracy actually represents solutions. Had it not been for democracy within the bar, we wouldn't be here, and we wouldn't be asking these questions from the heads of department. Ms. Sawori, thank you for being honest in the answers you gave us. They've helped us to design, initiatives that can help Ugandans address contemporary legal issues like that one. But for now, we concede there's no present capacity. We have to build it, and the primary material in which we can build it is the goodwill of the bar. And that goodwill is plenty. A lot of lawyers want to bang the table. They just want to be shown leadership and direction and organization. And our enemies want to obstruct that. They want to obstruct our leadership, our organization, and our ability to give you clear direction where to target your energies. Because they have corrupt arrangements in this system of injustice. They have accommodated themselves quite comfortably in what is a very uncomfortable situation for the rest of their fellow citizens. I thank you, Vice President, for guiding us through this. And I thank our colleagues who have been online throughout. Once again, if we don't have another engagement of this kind from the council, from the secretariat, management and staff, Merry Christmas. Maybe, Mr. Wall, you can come and address the public in closing.
All right, thank you, Mr. President. Let's give him a heart hand clap. President has stood there for the last 3 hours, from 2:30 to 5:30. I think we can give him another hand clap as welcome our acting CEO to come and give closing remarks as we close this space. Thank you.
Members online and present here, we don't take this for granted. Your presence matters a lot. Your contribution matters a lot. Thank you very much for putting all your questions across to the President, and he has ably answered them. Right now,